I'm Drew Stevenson, and this is a short lecture for my professional responsibility class about lawyer fees and legal ethics. This is actually my fourth video in the series about legal fees. And here we're going to give kind of a famous example of the problem with quantifying what counts as an unreasonable fee. So there's a tragedy that happened, kind of a big case in 1989 that I talk about the lawyers involved twice in the course. At this point, we're going to talk about the plaintiff's lawyers. Near the end of the course, I'm going to talk about something kind of sketchy that the defense lawyers did in the case. But first, the story, and it's a very sad story. On September 21st, this is a quote from the New York Times article about it. In 1989, basically a Coca-Cola delivery truck slammed into a school bus in Alton, Texas. And this was on an overpass over a high ravine. It sent the bus flying off of the overpass into the ravine far below, and it killed 21 children and injured dozens of others. The school bus was full of kids, if I remember right, on their way on a field trip. So this made national news, right? It was a really shocking tragedy. The driver of the delivery truck survived, by the way, and we'll come to that near the end of the course. So the lawyers or families of the victims got lawyers very quickly, and the insurers for Coca-Cola and the bus manufacturer immediately offered to settle before the case even before pleadings had been filed. The insurers offered to pay off the victims' families, for a total amount of $122 million. Now, the lawyers in the case, remember that they had signed up and they had agreed to do it on a contingent fee basis, not knowing how long the case would go on. But the problem was, as soon as they had signed up to represent these victims' families, the defendants offered to settle up front immediately for a very large amount, which created a windfall for the lawyers. So 5 years later, the New York Times kind of tracked down the lawyers and figured out how little work they had done on the case and how much they had received in their contingent fee from that $122 million. And so notwithstanding that early resolution of a case that was never really in doubt, the family's lawyers received at least a third of the settlement in contingency fees. And that sum was equal to at least $25,000 an hour to each plaintiff's lawyer involved in the case, in exchange for what amounted to nothing more than routine legal services. And so remember that Rule 1.5a says that legal fees have to be reasonable, and then it gives a number of factors of how to decide what counts as reasonable, how experienced the lawyer is, how involved the matter is, the result obtained, and so forth. Now, if as a lawyer you sign up a client and you decide that you're going to and you get an immediate very large result for the client, good for you, and you deserve a pretty high fee, a higher than usual fee for that. But the question is, if the lawyers didn't set out to seek an unreasonable fee, but they kind of received a windfall, I think for 1989, $25,000 an hour is unreasonable. If it was a tenth of that, if it was 2,500, considering how quickly this result accrued to their clients and how large it was, maybe they could justify that. Now, to my knowledge, the lawyers in this case were not the subject of a disciplinary proceedings. But if you're asked this as a test question, I think the answer is that would be unreasonable, that you could have a fee that's just too high, you agree to do a contingent fee matter, and then the matter settles immediately for an enormous amount. You're essentially getting paid millions of dollars for doing no work. And I think if this disciplinary authority decided to bring a disciplinary action, that could constitute an unreasonable fee in that case. And so it's a difficult example because I don't think the lawyers had bad intentions. And in this real example, I don't think the lawyers faced disciplinary action for it. But if you get a hypothetical like this as a test question, I think the answer is you could have a fee that's sort of accidentally a windfall that's too high to be reasonable, at least the way the rule in 1.5a is stated. And that's the whole point of this video.